right, let's bring you then some live proceedings currently on. Advocate Dali Mpofu, the legal counsel for Public Protector Advocate Busisiwe Mkhwebane, has argued that to suspend her while impeachment proceedings are underway would be punitive and cause reputational harm. The matter between Mkhwebane and the National Assembly Speaker and others is underway in the Cape Town High Court. Let's take a listen in.
The founders of the Constitution wanted to protect a person in the position of the public protector from all sorts of COVID-19, whatever happens, which might delay the thing. Just in the same way, Justice Erasmus, that a suspension of a judge in terms of 177.3 is upon the JCT, the structure of the JSC called the JCT. Remember, there's a JCC, which is the first committee, and then the matter goes to the JCT, and then from there it goes to something called the small JSC, which is the JC minus the MPs. So the founders of the Constitution said deliberately to protect our judges from the calamity of a suspension. They said, no, the fact that you might have a complaint and that complaint goes to the JCC, and even the JCC finds that it should go further, is still not enough to trigger a suspension, right, of a judge. One can say, but how can you, mothers and founders of the Constitution, say that when even the JCC process is now concluded and found that there's prima facie evidence, why can't we suspend? No. The mothers and founders of the Constitution say no. They have to wait only upon the JCT finding may you suspend. Doesn't matter how strongly you feel about it, or that the judge is accused of killing 1 million people or whatever. The suspension can only be triggered at a particular point. And I've explained to you linguistically that with the holders of public institutions, it must be assumed logically that the protection that is given to holders of Chapter 9 institution, heads of Chapter 9 institution, is at worst similar or better than that of the judges. And in a line of, if I ever write an article about this, I would say that it's better, but I'm happy to say it's the same. And I say that because the word after makes it clearer than in the question in the case of a judge. Makes it clearer that the judge is protected. The word upon in the case of a judge means it doesn't matter how many postponements the JCC or even the JCT can have. Only when it reaches a particular point can you do this. And you know that it can take many years to happen. Similarly, the founders and the mothers and fathers of the Constitution were saying the same thing. It doesn't matter, let's say the panel, there's a problem, then somebody gets sick, or they die, or whatever, or there's COVID-19, and all sorts of things happen. You can't say, hey, we're tired of this now. There have been all these postponements of the independent panel, or it gets dissolved and reconstituted and challenged. And the stories we were saying this morning, what if? It doesn't matter. The Constitution is very clear. And nobody knows that more than President Ramaphosa. He said it to Mr. Hoffman, that Mr. Hoffman, my hands are tied. I cannot suspend unless the process is started. He knows this.
But that's what I'm asking you. Forget about the dates.
Yes.
At what stage of the development of the process, the 17 steps, if one were to call it that,
will the
You
proceedings
say
start?
the process.
Okay, the short answer is I don't know. The long answer is that at worst, it will not be before the 11th of July.
That's when the evidence is presented.
Yes, that's when the presumably will be invited. That's when the judgment of the Constitutional Court hopefully will be obeyed. Because that judgment must not be looked at skewly. That judgment said full legal representation. When the process starts, you must have full legal representation. The only reason, Justice Erasmus, that we have not been invited to the meetings of the committee is because they know, they're just lying to you. They know that the proceedings that Justice Mkhwebane was talking about have not started. Otherwise, they would have invited us. Because the full legal representation is full legal representation. One doesn't need to be a genius in this. If you say I have full legal representation rights in the CCMA or whatever, then how can the CCMA proceed and do all sorts of things without me or my lawyer? It can't happen. Full legal representation means wall to wall, right? Means from start to finish. So that's what I was trying to explain, that these people are trying to fool this court because they cannot have it both ways. If they genuinely believed that the process has started, then they would have had the lawyers there. It would be us who say, no, we don't want to come because the process has not started. No, they know in their heart of hearts, everybody knows, everyone should know. It is very clear, and that is why they have not invited us. They know that the proceedings have not started, but they are jumping the gun because they want to suspend this person by hook or by crook, and mostly by crook. So and this is where we keep on going back to this 110 story. If on the other hand, let's be generous, they genuinely believe that the proceedings have started as envisaged in section 194(3)(a), then they are guilty of even something worse, which is contempt of court, which is plainly illegal. Because they then knowingly are depriving the public protector of her full legal representation, knowing full well that the Apex Court has ordered it. I don't want to put, that one is too ghastly to contemplate, as one PW voter once said. And I don't even want to go there. But those are the only two options, Justice Erasmus. There's no other option, with the greatest respect, that is available to these parties. And therefore, to round it all up, the public protector is only saying to this court, please, court, all these people are descending upon me, including the Abraham G's of this world. And as Justice Jafta said in the impeachment case, oh, sorry, just something. Sorry. Yes. The test is postulated for all these things I've said at paragraph 171 of SABC. And it is simply this. Forget the conspiracy theories about coordinated attack and all that. Even if the president genuinely but naively accepted that, as he says in his affidavit, well, what do you expect me to do? I got a letter from the speaker saying the thing is resumed. Well, firstly, that's just a lazy approach to this matter. Because the president can't do that. He can't simply say, well, I got this letter and therefore I want to suspend you. I didn't scrutinize the letter. I didn't take my own view. That would be illegal on its own, just for another reason. But the point I want to make, which is made in South Africa, is that it doesn't matter even if he genuinely did it. The test is objective, which is what you and I, Justice Delano, have been saying. Have the proceedings started or not, objectively. Not what the president thinks, or not what is worse, what the speaker thinks, and not what Mr. Janji thinks. And this is what the Constitutional Court said. The legally relevant question, it was a question of whether it was an interpretation point like here, as whether the meaning of the words matter of public concern. And here you can just transplant those to mean.
All right, let's take a break from that. We'll go back in a moment. That's Advocate Dali Mpofu there, representing Advocate Busisiwe Mkhwebane in that impeachment matter, which of course is now back in court. Let's take a look at what the weather has in store for us.